Los Angeles of California is the global hub for film and international business. After Washington, D.C., Atlanta, and Dhaka, Rajulo has inaugurated its fourth branch in the Little Bangladesh area near downtown Los Angeles. The office is located on the 12th floor of Central Plaza on Wilshire Boulevard. Rajulo is a full-service immigration law firm providing American immigration support all over the world through Google's state-of-the-art cloud technology. We stand out with a dedicated team of 7 accomplished attorneys and over 100 law clerks and case managers. Rajulo is your trustworthy destination for 100% accurate and reliable immigration service, ensuring your data security and peace of mind regardless of your location. We are proud to announce that our success rate is above 99%. To learn more about our Los Angeles branch, please contact the address and phone number shown on the screen.
Hello everyone, and welcome back to the weekly live session held by attorney Raju Mahajan and Associates. For today's session, I am your host, Isabella Rosario, and with us we have our founding attorney, Mr. Raju Mahajan himself. Mr. Mahajan, it is a great pleasure to have you here with us.
Thank you very much, Isabella. I welcome everybody to this show, those who are watching now or will watch in future in our different social media platform.
Yes. As usual, welcome to all of our audience members who are joining us from various platforms. If you have any questions, you can ask Mr. Raju Mahajan on this live session directly. This is a place where we have productive sessions. Today, our productive session is going to be on the topic, how to know why your visa was denied. Mr. Mahajan, please enlighten us on this topic.
Yes, thank you very much. Can I see the slide? Yes, thank you very much. So a lot of time, a lot of people who apply for a visa, they got denied for many different reasons. And then they send me an email like, hey, why my visa got denied? Especially recently, many of you already know that American government issued visa sanctions, visa restriction for people from Bangladesh who are involved with anti-democratic and anti-human rights situations. So many people, they are getting visa denied. And they want to know that is their visa denial related to this American visa sanction, or this is just a very normal visa denial? Because visa denial is nothing new. Like, people get denied their visa application left and right all the time. Last year, in the year 2022, around 64% visit visa got approved. That means around 36% visa got denied. So it's not just because of any government issues. Your visa may get denied for other reasons too. So the question is, how do you know why your visa was denied? How to know about that? That is the topic for our today's discussion. If you have any question, you can ask me after this presentation, or you can contact us later for more information. Next slide, please. So before we talk about how to know, first I need to clarify 3 terms. One is denied, one is refused, one is rejected. So a lot of people, they get confused with these 3 terms. Denied means after careful consideration, after evaluation of your application, embassy is denying your visa, meaning your visa application is denied. You are no longer getting it for this time. Of course, you can apply again. That's not the problem. But this time it is denied. Permanent denial. The second one is refused, meaning they considered your application, they reviewed it, and they did not make any conclusive decision yet. It is either pending, the application process, the decision is either pending, or they temporarily refused it. They did not permanently denied it. So refusal is better than denial, but still you did not get the visa. So this is a very confusing thing. So refused means you did not get the visa either, but your visa is not denied either. So your application is kind of still pending. Decision is still pending. The last one is rejected, meaning there's a mistake in your application. Some of the important information is missing, or some of the important documents are missing. That's why embassy is not reviewing your application. They rejected it. even before review it or making any decision it. So rejection is probably the best case scenario, meaning you did not get the visa yet, but it is not refused or denied. They just they even did not accept the application. They even didn't take the application. So rejection happens within a very short time. They first screen the application. If there's any important information or document missing, they reject it and say, go ahead, submit it again, kind of things. So these are the three terms you should be aware of. Next slide, please. All right. So how to know why your visa got denied and how to know it? The short answer is FOIA, FOIA, the Freedom of Information Act. This is a federal law. It helps you. And you means, who are the you? You means you can be a US citizen, foreign nationals, organizations, universities, businesses, and state and local governments. They can ask for any information held by US government to disclose it. Yes, sometimes they will not disclose everything. If there is any issue for national security or other thing, they will redact it, but they will disclose most of the information that they can disclose. So under this act, under the FOIA, you can apply to get a background, the copy of your background check, to see what, or if there is any bad things, any red flags or yellow flags in your application. If there is no red flag, no yellow flag in your application, and your visa still got denied, that means in most cases, a visa officer misunderstood your application. Visa officer got confused with something else, and that's why your visa got denied. There's a better chance that, yes, next time, if you mention that you requested for FOIA, there is nothing bad in your profile, then most likely in the next time your visa will be approved. That's why it is very important to know why your visa got denied. It is very important to apply for a FOIA, get your background check, a copy of your background check, and that will really help you in future. By the way, and when I say who may file, US citizen, foreign national, of course your attorney can also file for you. Also, any of the petitioner can also apply for the beneficiaries FOIA application. Of course, the petitioner or the attorney need a informed consent, they need a written consent from the beneficiary to get the FOIA request submitted. But yes, attorneys can do that, your relatives can do that, and of course you can also do that. So FOIA application, bottom line is, through the FOIA application, you can know about your background, and by knowing it, you can see if there's any red flag or yellow flag in your application that triggered the visa denial. Next slide, please. All right. Procedure to file a request under FOIA. So there is both online and offline application. I always encourage everybody to apply online because it is faster, it is more accurate, and it helps everybody. It helps you, your attorney, and US government officials to process the application faster and more efficient way. So please apply online, but if you do not like online, there's an offline option too. Next thing is, first identify the federal agency or department you want to make a FOIA request to. Meaning, every agency has their own procedure, every agency has their own resource for keeping all the records, all the data. So it doesn't mean that, let's say your information is held by Department of State, and then your information is also held by Department of Homeland Security. So you will not get all the information with one FOIA request. You have to submit separate FOIA request, one for Department of State, one for Department of Homeland Security, one for, let's say, other government. Let's say you have some data, like a New York City has some data from you. So you have to submit a separate FOIA application to New York City. So the first thing is you have to identify the federal agency or department or state agency or whatever. You have to identify the agency. Then each federal agency and department has their own procedure of filing a FOIA request, and it all can be found in the designated website of the agency. As I said, every agency has their own procedure, own mechanism. You have to follow the procedure and mechanism. Sometimes it can be a little harder for you. That's why I always encourage you to talk to an attorney who can help you, but you can do it yourself too. It's not a rocket science. It's easy to do. Next slide, please. All right. What is the initial fee of filing FOIA request? The good thing is there is no initial fee required to submit a FOIA request. And then some agency, they charge per page. Sometimes it's like a 25 cents per page, sometimes it's like a 10 cents per page, it depending on the agency. For some agencies free, they will disclose all of your information without any fee. So initially it is free, and then the designated agency will tell you how much they're going to charge you per page or for the entire document or whatever. So they will communicate with you about the fee. Next slide, please. Okay, what forms are required to make FOIA request? There is no specific form. I repeat, there is no specific form to make a request. One can submit a FOIA request to the agency's FOIA office. While making a FOIA request, the written letter / request shall contain a clear description of the information sought and as much as detail possible, including the contact information of the person requesting the FOIA. Reasonably describe the records being requested, must state that the request is being made pursuant to the FOIA and the category of the requester for fee purposes and reasons why the department is believed to have records on the subject. Bottom line is, there is no fixed form. You have to write a letter, and you have to tell them as much detail possible about the information, about the purpose, about the document, why you think they have the document, kind of things. That's why sometimes it's a little harder for you to do it, but yeah, it's a letter to and also every department has their own format, so please follow the format defined by them. Next slide, please. So this is the online FOIA request portal. If you go to, you see it, www.foia.gov. If you go there, you get all the information, you get all the online, portal kind of to fill up and submit it to them. Again, there is no specific form. You just need to fill it up and give all the detailed information, submit to them, and they will process your application. Next slide, please. All right, so this is a chart for every department, how to request records and forms, blah blah blah. I'm not going that detail into it. If you're interested, please check it. And remember, here I only mentioned about 3 departments: Homeland Security, Department of State, and Department of Justice. Every department, every office has their own requirements. So follow the specific requirements for the specific agency or office. Next slide, please. All right, where to submit the FOIA request? Again, as I said, every department has their own. So Department of State has, pal.foia.state.gov, blah, blah, blah. You can just copy it here and put in the Google, you'll find it. DEA, Department of Drug Enforcement Authority, Drug Enforcement Authority. This is their one. USCIS, this one. So just follow their requirement, follow their link. Next slide, please. All right, after FOIA. So let's say your visa got denied, and then you submitted a FOIA request, and you got your background check copy, and there is nothing bad. There is no red flag, no yellow flag, no bad information that may get your visa application denied. Then what you do? Then there are several options, and a lot of time when you talk about these options, a lot of people will talk about consular non-reviewability. The bottom line of consular non-reviewability is that when any embassy, any consulate make any decision, you cannot file lawsuit against that organization or decision made by that consular office. But it doesn't cover everything. That's why I'm not going that detail into consular non-reviewability. It's a very legal thing. What I'm saying is, after your FOIA application, if there's nothing bad, you can do few things. Number one, you can reapplication and submission of additional information. You can submit a new application with a copy of your FOIA documents that you retrieved from the government, and say that, hey, look, I do not have anything bad in my background. Why you denied my application earlier? This is a new application. Please approve it. So reapplication and submission of additional information will always help you. Option number 2, supervisional review. Anytime any consulate make any decision, any visa officer make any decision, they have supervisor. You can apply for a supervisional review, meaning the supervisor of the person who made the initial decision will review the application, and if there is any mistake by the visa officer, then the supervisor will fix it. Supervisor may issue a visa based on your previous denial. The last one is appeal a decision within a consulate. In some limited circumstances, the decision of consular officer may be appealed within the consulate. However, there are no procedural guarantee of this. So this one is more of like a discretionary power of the supervisor or head of the chancellery, of the ambassador kind of things. You can always file for a appeal, but this one is kind of like, it's not like a formal procedure, it's like a more of informal. But the previous two, reapplication and submission of additional information and supervisional review, they are more formal. Next slide, please. Also, there are some other options, and here I'm talking about the scope and exceptions. A few exceptions to the doctrine of consular non-reviewability is that, number one, there's a test called Mandel test. The consulate did, and the bottom line of the Mandel test is the consulate did not provide a facially legitimate and bona fide reasons for the rejection. Meaning, when your visa got denied, they did not provide any legitimate and bona fide reason for the rejection. They just said your visa got rejected, but they did not provide an explanation. And it might be infringe on the constitutional right of United States citizen. This one, see, I put an underline because this is very important for this Mandel test, which is if you have a relative, like a very close relative who is a US citizen, only then you can apply this Mandel test doctrine, and then you can also submit your writ of mandamus or other kind of review request. But remember, you must have a very close relative who is a US citizen. If you do not have a close US citizen relative, you are not qualified for Mandel test. The next one is, in cases where a consular officer rejects the application based on underlying statute or regulation, it may sometimes be appealed on these two grounds. Number A, claims that the underlying statute or regulation being applied is unconstitutional. This is very broad. It's kind of hard to do. I'm also admitted to US Supreme Court, so I can challenge any statute or something in US Supreme Court as unconstitutional. So if any statute they apply, we see that it's unconstitutional, we can definitely challenge it. The B is claims that the consular officer made a procedural error in applying the statute. This is of a more common one. It's more common than option number B, that consular officer made an error in procedure. So we can definitely appeal against this. So next slide, please. So bottom line, if it's just a long discussion, and a lot of time it's kind of like hard to remember what I said last 10-15 minutes. Bottom line, if your visa got denied, you can apply for a FOIA request. With a FOIA request, you can get a copy of your background check so that you can see if they have any negative information about you. If they do not have any negative information about you, there are multiple options to apply or appeal against the decision, and your visa application can be approved again. So that's like the bottom line of our discussion today. Thank you.
Thank you so much, Mr. Mahajan, for that enlightening session. I'm sure we all know a lot more about how to proceed if we get a denial status. For now, we are going to go back to the archive emails that potential clients or simply curious people have sent us regarding different kinds of queries about immigration. So please allow me some time to get back to those questions. Sure. In the meantime, dear spectators, if you have any question, please do comment and we will address those as well. The first question that we have is from, I apologize for the delay. Please allow me a second. Mm-hmm. Yes, the first question that we have is from somebody named 𝗦𝘂𝘃𝗟𝗶𝘆, and he is asking, how can I reapply or appeal if my change of status application is denied or rejected by the immigration authority?
Yes, as I said, if you get your, can you read the question again?
How can I reapply or appeal if my change of status application is denied or rejected by the immigration authority?
Exactly. First, we have to see the copy of your rejection or denial letter. We have to see it whether they mentioned any reason. If they mention any reason, we have to see if the reason is a legitimate or bona fide reason. If they mentioned a bona fide and legitimate reason, then you cannot do anything. I mean, you can definitely appeal, but your appeal is not going to be successful because they denied your application based on legitimate reason. However, the reason they mentioned, or if they did not mention any reason at all, then we will see if there's any negative things in your background that is applicable to this field. Remember, there could be some minor negative things. So let's say you have like a, minor domestic violence or minor petty crimes that is not you're not, that is not applicable in this field. In that case, we can also appeal against the decision. So I advise you to send me a copy of that denial letter or rejection letter, and if there is any scope of appeal or reapplication or writ of mandamus or any kind of administrative legal procedure, I will advise you based on that.
Thank you so much. Mr. Hassan has another question. Does Rajulaw assist a U.S. company job offer for an H-1B visa application? And if your company helps, then when is the right time to reach out to your company considering the H-1B lottery?
Yes. So if you are an owner of the company, I can definitely help you. You can reach out to us anytime. You can reach out to us today. For H-1B application, you have to submit application in the month of March, but you need to get ready. So I advise you to contact us as soon as possible. However, we do not we do not provide help to applicants to find a job. It is the applicant's job to find applicants who will find the job, and the company will contact us and we'll help the company. We cannot help you find a job here in America. But if you're a company owner, if you're a business owner, we can provide support to you any time of the year. So you can reach out to us anytime.
Thank you, Mr. Mahajan, for your answers. In the meantime, we have another one of our spectators commenting a question. Ms. 𝗂𝘗𝘆 𝗟𝗶𝘆 is asking, my question is regarding NIW. I have submitted all my documents to your law office through my case manager. I would like to confirm when my petition will be submitted. Thanks.
Thank you very much. It would be very hard for me to answer this question at this moment. I advise you to send an email to your case manager. Say, hey, I submitted everything. Can you just give me like a timeline, like a ballpark timeline? And they will definitely give you a ballpark timeline. In general, we take 35 to 45 days from beginning to end to complete our work and submit to USCIS. But sometimes it may vary depending on the situation. So I would advise you to send an email to your case manager, and she or he will be able to directly answer you.
Thank you so much, Mr. Mahajan. I hope that answers your query, Ms. 𝗟𝗏𝘟. We have another question from our archive emails, this time from an individual called Nishat Farzana. And she's asking, I overstayed my F1 visa by 68 days in 2021 and didn't apply for OPT due to personal issues. If I have a fully funded US PhD degree offer now, then what is my chance of getting a US visa in your opinion?
So there is still chance. There is still chance that you will get a US visa. But anytime there is any out of status situation, even for like a 1 or 2 days, that will create some problem for you. That's why I always advise people not to go for any kind of out of status, any kind of overstay. Even a day or two in overstay can cause your valuable green card. However, yes, there is still chance. There is still hope. I don't know whether you are still in America or in a foreign country. No matter where you are, you can definitely apply and see what the embassy officer is doing, whether they will approve it or not. If they deny it, you can contact us and we'll try to appeal against it. But yes, it may cause a little problem.
Ms. Farzana also asks, how can I prove that there is a valid employer-employee relationship between me and my H-1B sponsor if I work remotely or at a third-party site?
So first of all, H-1B is not applicable for remote worker. You must be here in America. And even if you work from home, it's like a hybrid or like an online, you must live within a geographical area to be qualified for H-1B. As a remote worker, especially if you live in a foreign country, you are not qualified for H-1B application. And the second one is, if it is for a third party, the short answer is the company who is running your payroll is qualified to apply for you for H-1B. If you are, let's say you are you're employed by ABC Corporation, and ABC employed you, let's say in Toyota, like Toyota Motor Company, and your payroll is run by ABC Corporation, then ABC will apply H-1B for you. Toyota will not do that. Toyota is not qualified to do that. So I hope you understand. It is determined by your payroll, like the company who is running your payroll.
Thank you, Mr. Mahajan, for your response. We have a query from Mr. Khalid Hassan, and he's asking, As a Canadian permanent resident, can I study in the US by obtaining an on-arrival visa, or do I need to attend a US Embassy visa interview?
You need a US visa interview because as a Canadian permanent resident or citizen, you are allowed to stay 90 days in America without any kind of visa, like on arrival visa kind of. It's called ESTA, EST. Sorry, for Canada, it's TN visa. So under TN visa, you can only stay in America for 90 days, but you are not allowed to enroll in the school, do any work or anything. It's just a visit visa. So you still have to get a I-20 from your university. You still have to apply for F1 student visa, get interviewed in US Embassy, and get the visa, and then come to America.
We have one final question from Mr. Khalid Hassan, and he's asking this time, I have been deported from the US. Now I want to apply for EB to NIW. Will my previous deportation have a negative impact on my visa application process?
Yes, it will definitely have a negative implication. And I have to see like what kind of deportation was it. If it was like a voluntary departure without any prejudice or anything, sometimes that may help. But in general, any kind of deportation will cause some kind of problem. And the longer longer out of status you were here in America will cause like a more problem. I need more information. But short answer to your question, yes, it will create some problem.
Thank you, Mr. Mahajan, for that response. Now we have another question from one of our spectators, Mr. Imran Khan, and he's saying, Assalamu alaikum. As Italians, we came to visit US and we tried to change my wife's status, student, as a spouse. Can I get work permit in the US? We have 2 kids. Can they go to school? Thanks.
So my understanding is that your wife will be a F1 student holder and you will be F2. No, as a F2 dependent, you are not allowed to work in America. You will not get any work permit. But your kids are allowed to go to school. But yeah, as a F2 dependent, they're allowed to go to school. But you are not eligible to get work permit, not eligible to work.
I hope that answers your query, Mr. Khan. With that, we no longer have any more questions. Thank you to all of our spectators. If you have any further questions, please reach out to us through our emails. We will be sure to answer you all. And thank you, Mr. Mahajan, for giving us your valuable time today.
Thank you very much. I thank you, everybody.
Yes, thank you, everybody. We will see you at the same time next week as well. Thank you and have a great day.
Los Angeles of California is the global hub for film and international business. After Washington, D.C., Atlanta, and Dhaka, 𝗦𝘂𝗍𝘆 has inaugurated its 4th branch in the Little Bangladesh area near downtown Los Angeles. The office is located on the 12th floor of Central Plaza on Wilshire Boulevard. 𝗦𝘂𝗍𝘆 is a full-service immigration law firm providing American immigration support all over the world through Google's state-of-the-art cloud technology. We stand out with a dedicated team of 7 accomplished attorneys and over 100 law clerks and case managers. 𝗦𝘂𝗍𝘆 is your trustworthy destination for 100% accurate and reliable immigration service, ensuring your data security and peace of mind regardless of your location. We are proud to announce that our success rate is above 99%. To learn more about our Los Angeles branch, please contact the address and phone number shown on the screen.